Welcome to the podcast, everybody. Today's topic is garden leave, which is not time that you take off during the spring and summer to plant your garden and or weed it or harvest your small little crops. Garden leave is a really important concept. And Tracey, there were some developments that came out after we recorded this episode that make this topic even more important, right?
That's true. The FTC recently published its final rule banning non-competes across the country. And while there's already litigation that's been filed that may change ultimately whether that ban goes into effect, in light of the FTC ban on non-competes, the concept of garden leave is even more important than ever because it gives employers another tool in their toolkit to protect their confidential information and prevent employees from competing.
Yeah, that's right. This is a really timely topic. So hope you'll stay tuned to the episode.
Welcome to Hiring to Firing, the podcast. I'm Tracey Diamond, labor and employment attorney at Troutman Pepper, and I'm here with my co-host, Evan Gibbs. Together, we tackle all employment and HR issues from hiring to firing.
And today we'd like to welcome our partner, Dan Sieck. Dan, why don't you tell us just a little bit about your practice?
Hey guys, thanks for having me. My name's Dan Sieck. I'm a corporate partner here. I sit in Boston. I tend to represent venture funds, venture-backed businesses, and then I do a lot of M&A that comes out of those venture-type deals. My client base is primarily in life science and tech, so pretty steeped in the venture world and everything in it.
Dan and I have had a chance to work together, and his clients are really interesting in the life sciences world. They're making some very interesting products that hopefully we'll be seeing, helping to really help people. Today, we're talking about the concept of garden leave. I'd like us to start with some definitions. Evan and Dan, can you please explain what is the difference between, what is garden leave, and what is the difference between a non-compete, a customer non-solicitation provision, and this idea of garden leave?
Sure, I can lead off. I typically think of garden leave as it's a period of time, typically, or I guess really I've only seen it at the end of somebody's employment at a company, and it's used to help, typically, at least in my experience, is used to help transition someone out of the company. And the purpose that I've seen clients use it for is to have someone available or to have that employee, that person available to provide transition assistance. So, for example, if you've got a chief marketing officer that's leaving the company and you want that person to assist the new chief marketing officer, one option is to offer the outgoing CMO, offer them some garden leave where you pay them some amount, maybe the same salary or some different amount, and they're available on a limited basis for a limited period of time to provide those types of transition assistance duties. They're ongoing, whether it's employment or consultancy, it's limited in time and scope typically, and it's, very limited duties and short in time. That's typically how I've seen it. And the difference, with a non-compete and non-solicit, you can sign those agreements at the beginning or, at any time during employment, and they, prohibit an employee from doing certain things, competing or soliciting, typically without regard to whether there is any type of paid leave that is given to the employee during the non-solicitation or non-compete period.
Yeah, and the only thing I'd add on there, I'd never heard of garden leave until a couple years before the pandemic when Massachusetts adopted some new laws that required it. I sit in Boston. But, as Evan was saying, it's the historical practice, at least in the U.S., has been to have some kind of non-compete, non-solicit series of covenants that you impose on your employees or service providers. And this concept of garden leave, at least in Massachusetts, as I understand it, sort of evolved out of that. And a lot of the discussions that were going on at the time about whether that was really unfair to the employees. And there was vigorous debate in the state government about this whole non-competes in general. And on the one side, there's the employee rights type people who are saying, oh, you're stifling competition, you're preventing folks from being able to go and work for a competitor. That's not fair. And then on the other side, you've got all the employer side advocates saying, well, it's also really unfair to basically allowing folks to come in and learn a lot of knowledge about a company and then leave and take that with them. And my understanding was this idea of garden leave, which we might have pulled from across the pond, is sort of a way to strike a balance there. And, you're going to pay somebody to ride out that non compete, non solicit period.
Yeah, that's right. That's a good point about other countries because it's a lot more common in some other common law countries and some other countries as well that don't follow the common law. But it's a fairly common concept outside of the U.S. But in the U.S., I mean, it's very uncommon. We were talking, listeners, we were talking before the episode started. We were kind of talking through our experiences with the garden leave. And I only deal with this, once or twice a year, if that. It just doesn't come up very much.
Yeah, you see it a lot more in the financial services industry. So in New York, it's much more common than it is outside of New York. I'd like to dive a little bit into the Massachusetts Non-Competition Agreement Act that Dan was talking about, because it is very unique. But before we do that, let's pull in our TV show. So as we always do, we use a TV show or movie to kick off our discussions. And for today, a TV show we're going to listen to is Silicon Valley. The show is about a computer programmer named Richard Hendricks, who quits his job at a company called Hooli after receiving seed money from a competitor to fund his app called Pied Piper. In this clip, Richard's friend Nelson Baghetti, who's referred to as Big Head, who is still working at Hooli, is essentially placed on garden leave when all of his job responsibilities are taken away from him. Let's take a listen.
Okay, so I have been instructed to remove you from the list of employees assigned to the Nucleus project. You will no longer receive any Nucleus-related communications, file reports, or attend any Nucleus meetings. Any questions? No, that's pretty clear. Great. Am I being reassigned to something else? Not that I'm aware of at this time. No. Wait, so then am I being fired? Because I have a 3-year contract and my stock options don't fully vest until after my 3 years. Nobody's being fired. Okay. Look, a contract is a contract. You've got a contract and I've got a contract. We all have contracts. And here at Hooli, contracts are honored. Yours and mine, everybody's. So, have I made that perfectly clear? Yeah, no, that's clear. But when I come into work tomorrow, what do I do? That is unclear at this time.
So one of the things about this clip that I thought was interesting, and it kind of goes to what you said before, Evan, is this idea of, is the employee going to hang around while they're on garden leave, or are you going to kind of exclude them from the workplace and cut them off? In the clip, Big Head, as I like to refer to him, is pretty much hanging around, but not given any job responsibilities. Evan was talking before about this concept of sort of transition time, where employees are available during their garden leave period to answer questions and help transition their duties to the incoming person that's going to be taking over their job. Do you see any sort of benefits or, pros and cons of allowing someone who's on garden leave to continue to have access?
I mean, I think so. And when I'm talking through this with companies, you've got to be really careful about the parameters that you put in place because, you don't want, for example, someone who's on garden leave to start working directly for a competitor, right? I mean, that's something you would want to be really careful about. You want to, depending on the nature of the circumstances that are at play in any particular given situation, there may be concerns that the person might, try to take some kind of data or documents on the way out the door while they're on this sort of garden leave period where they're sort of an employee, sort of not. And so I think you have to be really careful and you have to put clear parameters in place, not just in the contracts, but also from a practical perspective. You got to think through, should the employee continue to have a company computer, for example? Should they continue to have access to all the files and data that they had when they were an employee? You got to think through those sort of practical ramifications when you're...
Can they email employees still, or are you going to cut them off from their email access?
Exactly.
That kind of puts you into a strange position, I would think, though, if you don't have those indicia of, employment, if you will, but you are still technically an employee. I mean, it's starting to get hard to understand, exactly what your status is at the company, what authority do you have? Maybe you have no authority. So I think that, when I'm thinking about this, and even being in Massachusetts where there are requirements to at least consider it, I think we still aren't seeing all that much garden leave, in part perhaps because people just don't fully understand it. I don't know if you guys think that may be part of the reason why it hasn't been adopted to the same level as it has outside of the US.
Well, in our second clip, we see a good example of, an employee who is still allowed access to the company premises, but he doesn't really know where he fits in the scheme of the company anymore. In this next clip, Big Head wanders up to the roof of the building where he finds other garden leave employees just hanging out, basically drinking coffee and beer and waiting out their vesting period. Let's take a listen to this one.
I'm in year 3 of a 5-year deal, and Matt, you got 3 years left? Yeah. We all got acquired by Hooley, and we didn't work out. None of us got reassigned because Gavin believes in this Japanese form of management where not being assigned is the most shameful outcome.
Yeah, it does feel uncomfortable.
No, give it a week or 2, you'll get numb to it.
But why are you guys still coming in?
Rest and vest.
Oh, because in order to fully vest your options, you've got to wait until your contracts are up. I get it.
You catch on slow, you'll fit right in here. Lunch? Arby's on El Camino, I'll drive.
No, let's walk and take longer. Better use something to fill the day, right?
I'd like to talk for a minute about the Massachusetts law because it is very unique and it really marries the concept of non-compete with garden leave. So Dan, to what you spoke about before, my understanding of the statute is that if you want to put in place a non-compete, you have to offer employees garden leave equal to 50% of their pay during the period of the non-compete or some other, quote, mutually agreed upon consideration. So I think why we're not seeing too much garden leave is because a lot of employers are relying on that second prong with the alternative of some other mutually agreed upon consideration. There's not a lot of case law out there yet as to what that really means and what would be considered sufficient. Have you seen that in play?
Yeah, absolutely. The other thing that I was just thinking about, though, and sort of question that I'm often asked by especially early stage businesses that are confronting the Massachusetts law for the first time, if they have employees in Massachusetts, they're often asking me, well, why don't I just say that the governing law is another jurisdiction that doesn't have this kind of complicated regime and just use that? I mean, and I look to you guys for answers there.
Yeah, and I would think, and I'm definitely not a Boston or a Massachusetts expert, but I would think the problem that you have typically is if your home state has adopted some kind of statute on a particular issue and has taken sort of a strong stance on something like this, then a lot of times what will happen is a court in that state, so a court in Massachusetts, for example, may refuse to honor another state's choice of law provision where another state does not have those same garden leave protections in place. And they would basically say, hey, we've expressed a fundamental public policy in Massachusetts that people should get garden leave when they're, sitting out due to a non-compete. And so we're not going to enforce, for example, we'll take the most draconian law, Florida law, and we'll say we're not going to enforce a Florida choice of law provision in Massachusetts because it's against our public policy. The legislature has adopted.
By draconian, you mean most friendly to the employer who wants to enforce the non-compete, right?
Correct.
Yeah.
Correct.
It always depends. Draconian to you may be freedom to someone else.
That's right. That's right. And, I see there's always a balance. Florida's just, I know this is a bit of a tangent, but it's just so wild because it says in the statute that the judge shall not consider the hardship on the employee when deciding whether to enforce a non-compete. And I just feel like it's just so mean. It's just like, just club them to death. It's like,
you could be homeless because you can't find another job, but we don't care. We're enforcing that non-compete.
Do not care about their homelessness, judge. Yeah. You shall not.
Well, Evan, your concept of choice of law is absolutely right. I've actually looked at the Massachusetts statute quite a bit, and there is language in the statute itself that says that if an employee lives or works in Massachusetts, you cannot apply another state's law as the choice of law provision to try to make an end run around the Massachusetts statute. So
I need a prize for this then.
good
I think, if this was like a quiz show, I'd get some
guess.
kind of. That's right. That's right.
So, and California is another example, right? Outright ban against non-competes, and very clearly it has been articulated that you cannot try to apply another state's law, like Florida, to a California employee to try to get around that ban.
Yeah, I've seen a lot of companies trying to get around this by using non-solicits and confidentiality clauses that might pick up things like trade secret. I don't know. Are you guys still seeing that as a viable alternative to get around the whole non-compete issue altogether?
It can sometimes get around the non-compete issue. In Massachusetts, a non-solicit is expressly outside the restrictions of the act, but not in every state. Illinois is a good example. In Illinois, there's a Freedom to Work Act, and it applies a salary threshold not only to non-competes, but a lower, but still a salary threshold to whether or not you can apply a non-solicit of customers provision as well. Although the Illinois Act, interestingly, expressly excludes garden leave from the definition of a covenant not to compete. So that's another state where I'm surprised we haven't seen it yet. I think we will start to see it more and more, where the concept of garden leave would be applied for companies that are really concerned about keeping employees or recently former employees on the sidelines for a period of time to avoid the competition.
Yeah. So what are y'all, I'm just curious, we've talked a lot about the garden leave, we talked about some of the specifics, but what do y'all see as really the pros and cons? When a client asks about garden leave, what do y'all tell them about the pros and the cons?
Well, one of the cons is it's expensive. You're paying for the employee to sit on the sidelines, right? You're paying for Big Head to hang out on the roof and drink a beer.
Rest, invest.
Rest, invest, yes.
That's right.
And you're also probably bringing in someone new to do that job. So you're probably double paying for the same job to get done as opposed to a non-compete, particularly in a state where you don't have to pay for the non-compete. You're just tying the employee's hands for a period of time after they leave employment.
Yeah. And I think the pros are, in my opinion, having especially, I really see this a lot. If you got somebody who hasn't been there, been in a company for a long time, to me, it's not necessarily as valuable unless they're just in a really, really critical role, like an R&D department or something. But having the employee there, especially somebody who's got a bunch of, historical, organizational knowledge, can be really helpful. Having them around for the transition is what I've seen in the past. Somebody who's been in a company for, 10, 15, 20 years, and they're leaving, they can really leave a void, just a big knowledge gap if there wasn't, legacy planning in place, which is, often the case. And so I found that a lot of clients, that's what drives this decision, is having somebody around to help with that, be available for that, knowledge. Because of course, once an employee leaves, if they're not, contractually obligated in some way to cooperate, you call them up and ask them questions, they could tell you to pound sand, say, I don't work for you anymore, buddy. There's no way I'm, sharing all this with you. So it can really help in certain situations.
I could see that being an issue with the cooperation clause too, right? If you have a company that's in litigation or being investigated by a government agency and that employee has all that knowledge, having them on garden leave or some form of transition period where they're required to cooperate with you and still have the duty of loyalty of a current employee could be really important.
Yeah.
Yeah, I think from the board's perspective as well, you want somebody to stick around your employee. If you're not terminating them for cause, it's not a bad leaver type situation, and you want them to stick around. I think it allows folks to save face maybe on both sides, but to say, hey, well, we're not terminating you, and, we're asking you to stick around. And so, that's on the employee side. And then on the company side, the board side, we're not just going to accelerate all of the vesting of your options. We're still going to require you to do something, even if that something is minimal. And I think that's an easier pill to swallow if you're in a situation where the person's being let go, not necessarily because they did a bad job, but because, I don't know, the company's changed direction or it's kind of a light termination, if that makes sense. So I think there can be some value there.
I like that phrase. I'm going to use that. This is a light termination. This is
Never light.
this
You're
is not a
lightly
heavy
losing your
termination.
job. Yeah.
That's right.
I've actually seen like a sort of informal garden leave type situation where the employees basically said, hey, look, your future here is finite. We don't really see this going forward, this relationship, but we really want to give you time to find another job. So we want to give you sufficient runway here. And so, it's now April. You have till the end of the year. Start actively looking for a job. We're going to take away most of your job responsibilities so we can free you up to start looking for another job. You're still employed here, but understand the employment's not going to just continue indefinitely. It's sort of another tool in the employer's toolbox to end things in an amicable way where, to Dan's point, the employee saves face and actually isn't leaving until they've hopefully found another job in all that period of time. But it's letting the employee know that their job here is not secure forever. A lot of trust needs to be involved there, right? That the employee is not going to go crazy on you and create a toxic situation. So I can only see that working in certain situations where there's a real amicable relationship.
Yeah, that's right. I think that's a really big component to whether or not this is appropriate. It's a huge part. Have either of you dealt with a situation where someone was placed on garden leave and they were a commission-based employee? And if you have, I'm just curious, how you dealt with the commission part. And I know a lot of that's going to be driven by, if you've got a comp plan in place that says, there's certain definitions that you have to comply with. I could see the contract could drive that, or if they have an employment agreement that has that spelled out, you may have to follow that. But I'm just curious if either of you have ever had that come up.
Yeah, I'm not sure how you'd calculate commissions when someone's on garden leave if they have to actually be affirmatively out there selling in order to be eligible for commissions. But I would imagine that's probably a negotiation point of how much are you going to pay this employee to be on the sidelines and not be out there earning commissions. If they're not getting their full pay, then I could see where that could really lead to problems.
Yeah.
Yeah. I can't say I dealt with it, but as a practical matter, it feels like it'd be a challenge outside of a one-off negotiation.
Do you think there are any legal issues with the concept of garden leave?
I mean, I think there are some issues that certainly come up that are, can be a little tricky. For example, when do you have the person sign their release, right? Because, of course, if you're doing this with an employee, you're absolutely going to want to get a release of claims from the individual. And so, you've sort of got 2 points at which you would probably want to do so. You've got at the end of their, and again, it sort of depends on the type of relationship they're going to have going forward. But if they're ending their employment with the company and they're going to become a consultant, for example, if you structure it that way, a consultancy relationship, then, you'd want to have for sure a release at the point where their employment ends, so that you've sort of captured all those claims, and then have another one perhaps at the end of the consultancy or at the end of the employment period, so to speak. That's how I've done it in the past, is have 2 separate releases, one at the beginning of the garden leave and then another at the end, so that you make sure you capture all of the possible claims that they could have. So that's one thing you have to think through, because of course, if something happens, just because you place somebody on garden leave, it doesn't insulate the company from claims that could occur during that period, right? I mean, the person can still claim, a breach of contract. If they continue to be an employee, they've got those various employment claims out there that are available to them, everything from wage hour to disability claims. So, I mean, there can be, various types of risks that continue, even though you've got this contract that provides for garden leave.
Yeah, that's a super important point. And I do it the same way, where there's 2 releases, one at the end of the active employment relationship and the other on the actual separation date. But it's a little messy,
It is.
and it's a little more complex than just a single release.
I always get a little nervous on the second release, what the consideration is going to be and whether it's meaningful.
Absolutely.
That's sort of a practical issue that I get nervous with when we're talking about the sort of 2-step process. I don't know what you guys think.
What I've done, I can tell you on that point, I've had the same concern. And one thing that I've done is clients have given basically a garden leave completion bonus at the end. And it's like, basically, hey, at the, the last day of this consulting agreement, you'll get a, $5,000 bonus if you sign the release.
After we're done paying you to do nothing, we'll pay you more to go away.
Yeah.
Exactly.
I've actually seen it done, and I've done it this way where it's not 2 releases, but just sort of a transition letter agreement at the end of the active employment period and the beginning before the transition period starts, where it's laid out the sort of carrot and the stick of, if you stay available to us and transition your duties, then at the end of the transition period, you'll then be eligible for X amount of severance in exchange for a release of claims.
Yep.
One way to do it.
That's right.
What about benefits issues? I know we're not benefits lawyers and we don't want to, dive too deeply here, but do you see any potential benefits issues with this concept of garden leave?
Man, the benefit stuff is scary to me. I'll just tell you. Benefit stuff comes up. I'm calling the benefits lawyers. If they mention 409A, I'm like, nope, I don't know. I have no idea. I don't know what that means. I don't know these, there's a 281G. Like, I don't know. I don't even know what that means. I just can't even touch it. I would assume that there's like plan issues. I mean, I think you'd have to talk to your benefits counsel and understand exactly how this is going to impact, health insurance and, any of the other benefits, especially, options, all that stuff. What have you seen, Dan? Have you had those types of benefits issues?
Yeah, I mean, I know enough to be dangerous with respect to equity compensation. And typically, I can't really speak to the way the benefit plans work, but I agree with you that there's some stickiness there. But on the equity comp side, you ought to be able to continue to vest during either a garden leave where the person remains an employee, or even if they continue to remain with the company in kind of a consulting relationship. Whether you actually go that way or whether you just accelerate the vesting to give them what they would receive is kind of a case-by-case basis, perhaps could form part of the consideration for one of the releases you need. But, I know that's in my world when we're talking about especially tech companies where a big part of the comp may be tied to equity, that's meaningful. So that's real appealing on the employee side.
You mentioned consulting agreements, and I think it's worth a little discussion here because that is sort of a adjacent type of relationship that could be created at the end of an employment relationship sometimes if it's structured properly to provide some extra transition time to individuals, both in terms of giving them some money and also getting their expertise. Have you used that tool, and do you see any risks or benefits to using a consulting agreement after the end of an employment relationship?
Yes, I've used it. I probably should flip this to Evan, but I mean, the thing that makes me nervous in that structure is whether the person who was an employee yesterday is the consultant tomorrow, whether we're walking into kind of a wage and hour type claim or, whether they're actually an employee. That always, makes me nervous enough to call one of you guys. I don't know how you actually thread that needle.
Yeah, I mean, and there are certainly some rules you've got to be mindful of when you structure this arrangement, including, it's the same sort of analysis that we would, I think, go through for any type of independent contractor that the company was going to hire. We'd go through the factors of, how much control we're going to have, how much, sort of how we're going to control the employment, how are they being paid, is it hourly, is it flat fee? And so, I mean, you just kind of walk through those things and figure out exactly what you want to do. But again, it's really going to be, this arrangement is going to be a creature of contract. And so I think you've just got to think through it when you structure the contract and make sure that you're, considering those issues when you're doing that. I know I mentioned earlier, deciding whether they're going to have access to, company systems, or they're going to need their own equipment. And if they're doing it, if it's more of a consulting type arrangement, I would lean towards the person, using their own computer, using their own phone, things like that to make it more of a true sort of independent contractor relationship. That's sometimes the reality is sometimes it's just not that practical. And I think especially for limited consulting arrangements that are, really short in time, like if you've got like, let's say a 2 to 4 week consulting period, the wage and hour issues, even if it's sort of not perfect, the analysis isn't perfect, the risk of a claim is, it's pretty low, and any damages associated with that type of claim will be pretty low. So you just have to carefully think through how you structure and what the risk profile looks like. But those are certainly issues to be mindful of when you're putting together the agreement.
Yeah, I would agree with you that the shorter the arrangement, the less risk there is. So keeping the arrangement short is important. And then the only other thing I would add is that there are, just like with the Massachusetts Noncompete Act, there are statutes in certain jurisdictions that govern the independent contractor relationship and may make it more difficult to structure. So Massachusetts is one of them. You are in a highly regulated state, Dan. Massachusetts has an independent contractor statute that requires, in order for the person to be properly classified as an independent contractor, and I'm fudging the words here, I don't have it in front of me, but the basic gist is that they have to be sort of in their own established business, and they also have to be not performing the work of the business. So if you're making widgets, you cannot in Massachusetts have an independent contractor making the widgets for you, or you'd be violating the statute. It's called the ABC prong. And so really be mindful of those statutes when you're structuring the relationship.
Yeah, and that's something we didn't really touch on really, I think, clearly is the length of the relationship. And I can't really, it's hard for me to envision a scenario where I would recommend to a client that this lasts more than, like a month or two tops, right? I mean, it can get messy and complicated if this lasts for very long. And typically, to me, the sweet spot is like 2 to 4 weeks. You've got a plan to use them, how you're going to use them. You get what you need from them, but then, you ultimately have that permanent parting of ways after, not too long, because you just don't want to get in this weird gray area and thing's dragging out,
Yeah, I would say I typically see more of a range of 3 months to a year, so a little longer out than what you're seeing, Evan. And I really just think it's a question of sort of risk tolerance, and also where is the person doing the work, and are there any statutory restrictions?
Very interesting.
All right. Well, this has been a super interesting discussion. Thank you guys so much for joining. And thank you to our listeners. Please subscribe to our podcast as well as our hiring-to-firing.law blog. And shoot us an email. We'd love to hear about topic ideas, TV shows that you want us to talk about, movies. And speak soon. Listen in. Bye-bye.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.